For admission, item number 1.
Yes.
Now, my lord, in this case, as far as I can see, my lord, warrant of arrest was issued
Yes.
against
So what
respondent number
happened?
6.
Was it executed?
Your
The
Worship,
warrant?
from the information that we have acquired from the file, it was sent to the SP Aizawl. But I will have to obtain instructions on the status.
So find out where is he. He should be here. We were expecting his appearance if he was given bail, because it's a bailable warrant of arrest, isn't
Yes,
it?
yes.
If he was released on bail, we are expecting his presence here. So you should find out beforehand. You should see where is he, isn't it? Because then you are also involved, the state is also involved here concerning the execution of the warrant. Yes, what do we do here? We will have to fix a short date?
The superintendent of police is to come out.
Or the presence of the SPs will be required?
Your Worship, let me obtain instructions from the SP regarding the execution of the warrant. Because as far as my knowledge is concerned, bail application is not yet filed from this before this honorable court.
So we will fix another date. Should we fix it before you leave? Today's, maybe tomorrow also. Fix it tomorrow. We'll fix it tomorrow for his this thing, isn't it? That has to be done first. Yes, Mr. Joseph L. Rentley, learned counsel for the petitioner, is present, along with Mrs. Mary L. Kiangte, learned government advocate for respondents number 1 to 4, and Mr. J.C. Lal Nunsanga, learned counsel for respondent number 5, who has appeared through VC. Full stop. Then, new parade is seen that this court, in its order dated 07/11/2025, had directed the issuance of warrant of arrest within brackets, bailable, close bracket, against the respondent number 6. However, the respondent number 6 is not present today, and the learned government advocate has prayed for time to get instructions in the matter. In view of the above, this is the matter, tomorrow's date, okay, on so and so, wherein the personal appearance of respondent number 6 is expected on the execution of the warrant of arrest within brackets bailable issued against respondent number 6, failing which the personal appearance of the superintendent of police will be required. Yes.
Obliged, madam.
Item number 2.
My Lord, I am appearing for the petitioner in this matter. This is regarding Aizawl to Lunglei Road construction, maintenance and repair of the road.
Yes.
My Lord, I would like to take you quickly to the last order, which you directed the government to file affidavit 24/9/2025. You directed to file affidavit 24/9.
Yes, 24/9, we had passed a long order, things to
Yes,
be
my
done.
Lord, here, and we had filed the additional affidavit, so we enclosed certain photocopies of the roads. So your Lordship directed that the present status of the road was not good at all. So you directed to file the report of a committee, and also regarding fund diversion. So my Lord, as of now, they file it. If you kindly read, allow me to read, my Lord, please.
Which one?
That the last order, that 24/9.
24/9, So here, read the portion which you want to highlight. It's a long order.
Yes, my Lord, here we have perused the photograph enclosed and find the roads are still very much in need of proper maintenance and repair. It is also seen affidavit has enclosed a copy of report of a committee on estimates formed by the 9th MLA to conduct a detailed study of the conditions of the road from Aizawl, Tenzol, Lunglei, Walbank Road. The committee submitted its report before MLA on 5th March 2024. At the last part of the report at point 3.9, the report stated as follows. The committee firmly recommends that accumulated funds, including the mature fixed deposit amount, be utilized exclusively for ATL Road. This fund must not be diverted to any other projects or purposes. The committee emphasizes that such funds should directly benefit the ATL Road, ensuring that the resources allotted for these projects are used effectively and in alignment with original funding intent. It is evident that under no circumstances should the funds allotted for the repair of Aizawl, Tenzol, Lunglei Road be diverted. However, the state respondent had diverted a huge chunk from allotted total amount of rupees 90.69 CR for repair of road beyond Aizawl, Tenzol, Lunglei Road. Additional affidavit has enclosed a copy of the letter dated 34 issued by Undersecretary Finance Department sanctioning 58.9 CR to PWD for rehabilitation and strengthening of ATL Road. It is since that in the report given by the Committee on Estimates regarding Aizawl, Tenzol, Lunglei, Walbank Road published by MLA, the Committee of Chapter 4 has given its summary and recommendation regarding improvement and maintenance of the said road. In view of the above additional affidavit filed by the Land Council for the petitioner, the state respondent is to file their additional affidavit, taking note of the recommendation made by the Committee on Estimates, and also address the point concerning any diversions of funds which were meant for the repair of Aizawl to Tenzol Road. Affidavit of the state respondent are to highlight as how the sanction amount 5.8 CR, Vice Sanction Letter number 38/2000, has been utilized for the improvement and maintenance of the said road, at least after 4 weeks. My Lord, in this respect, and
They have filed the affidavit.
they had filed it, my Lord, and my Lord, the affidavit only stated that it was sanctioned, but this fund was not yet utilized. And it was recently approved by the state government, and they have abated about diversion also, and they have not even selected, they have not issued tender also. If you kindly see para 4 here, para 4 of their additional affidavit, compliance to the last order. It starts from page number 19.
Yes.
Here, my Lord, it was sanctioned and the fund is not yet utilized. And also, my Lord,
Okay, because fund is not yet utilized as AA and ES is recently approved.
yes. And also, my Lord, one query you asked regarding diversion also. They have not mentioned anything.
Yes.
Your Lordship, the funds is not utilized.
So there is
because-
this amount of funds. So utilize it so that the roads are repaired,
Yes,
isn't
yes,
it?
it is in process. Tender has to be floated yet.
Has to be floated.
Your Lordship, it was approved in the latest as 16th October 2025. Now, it's recently. So it's in process, it's under process. And with regards to the funds diversion, Your Lordship, there is nothing on records to show that there is diversion. So
This is an
there is a
allegation
sanction,
only, huh?
yes.
You have to show how it's diverted. Anyways,
It's not diverted. It's
Ah,
not
so
diverted,
it's-
now it's sanctioned. And
so it
yet,
is the petitioner who
Yes.
has to show how it
Yes,
is diverted,
yes.
isn't it?
But
So
we
that
have
you can
already
give a
enclosed
concrete-
and
This
then
is an
the order-
allegation
Yes.
which you says that no fund has been diverted because this amount, the AA administrative approval and the expenditure sanction, okay, was recently approved, isn't it? AA and ES. Therefore, maybe by the next court date, the further steps taken for improvement, and it has to be done fast.
yes, yes. I will-
Because now it is the month of November.
November.
By March, again, the monsoons will set in. I mean, some rainfall will be there. So you just have a window period of about 2-3 months you have to work. You can't, this thing, delay here. And then the next excuse will be monsoons, we cannot work, isn't it? Anyway, heard Mr. J.C. Nalnunsanga, learned counsel for the petitioner, who appeared through BC. Full stop. Also heard Mrs. Mary L. Kiante, learned counsel for the learned government advocate for the state respondents. Full stop. Yes, anything you want to mention here? Yes.
My lord, if you kindly see the last order passed by Chief Justice also.
Yes, yes, I've seen it.
Because the status report is not filed by Engineer-in-Chief.
Yes, are you representing the engineer-in-chief also?
Yes, Your Lordship, all the state respondents.
Learned counsel for the petitioner submits that the additional affidavit filed by the state respondents on 07/11/2025 does not fully address the points highlighted by this court by its order dated 24/09/2025. And the additional affidavit does not show how the sanctioned amount of 58 crores 99 lakhs have been utilized for the improvement and maintenance of the road a stretch between Aizawl-Thengzol-Lunglei Road. Full stop. Then new para. We have perused the additional affidavit filed by the state respondents, wherein they have highlighted the various steps taken by the respondents for the maintenance of the said stretch of road. And it is further mentioned in the affidavit that the amount of rupees 58 crores 99 lakhs, which was sanctioned white letter dated 30/04/2025 for the improvement of the maintenance of the said Aizawl-Thengzol-Lunglei Road is not utilized till date, since the administrative approval and expenditure sanction was recently approved by the state government on, where's the date?
16th October 2025.
16/10/2025. Full stop. The learned government advocate submits that the state respondents are yet to issue a tender for the works to commence within the said Aizawl-Thengzol-Lunglei Road. Full stop. She further submits that thereafter the state respondents will immediately take steps for the maintenance and repair of the said stretch of road. Full stop. New para. We have considered the submissions made by the learned counsels and have also perused the affidavit, additional affidavit, filed by the state respondents. We find it appropriate to direct the state respondents to take the further necessary steps for the maintenance of the Aizawl-Thengzol-Lunglei Road expeditiously on finding that they have the administrative approval and expenditure sanction has already been made by the state government, and that the state respondents should utilize the said amount of rupees, again copy paste it, expeditiously. Full stop. List the matter again after 4 weeks, okay, wherein the state respondents will inform this court of the steps that have been taken by the state respondents. Yes.
By way of affidavit, my lord?
Will an affidavit be required? I'm just-
Because last.
Okay, by
in the
way
last-
of an affidavit, by way of
last
affidavit,
quarter,
okay,
yes.
with the sanction, well, okay. Yes, list after 4 weeks.
Much obliged. my lord.
Item number 3.
Yes. Is it completed? Yes, completion report, is it?
Not yet, Lordship.
Because 90 plus amount was the works that remained.
My lord, the finishing work, yes, the whole construction of the building, structural works have been completed. However, some minute details have to be completed, as like painting works and the asphalt, laying of asphalt is yet to be completed and is still going on.
As on date, all the structural works for the bridge proper has been completed. So what's this, number 1?
Approach slab construction. This is the department's work, actually, my lord.
Wearing course. Then protective and finishing works, painting. So before 15/12/2025, is it?
Yes, my lord.
Now, this is a letter which is addressed to the chief engineer, to the state government.
Yes, my lord.
And this letter is dated
8/11,
8/11.
my lord.
So what is the, reaction of the state government?
My lord, I'll have to get instructions. I've just received this this morning, so I'll have to get instructions regarding this.
Then we'll list it after 15/12. So they have asked the state government for extension of time, 15/12. Now the state government, they don't know whether they're going to allow the extension or not.
My lord.
Yes, so we'll fix, when, in the next week, get instructions. What about the petitioner? What do you have to say? It's going on, isn't it?
yes,
Almost
Lordship.
completed. So
It's
let's
almost
see on the 15th and 12th. But in the meantime, this is just a letter
My lord.
asking the state governments to give them further time to complete the work,
Well,
isn't it? So we'll list it in the next week, get instructions. Miss Rosalind
Yes, Lord.
Elmar, learned counsel for the petitioner, is present, along with Miss Valentina Lildimpui, learned counsel for respondents number
One, my lord.
1,
Private.
and Miss Linda L. Fumble, learned additional AG for the state respondents. Full stop. The learned counsel for respondent number 1 submits that they have completed all the structural works for the bridge, and only minor works are still left to be done, such as the number 1 approach slab construction, within brackets, Zampui side and Byberry
Zamwang.
side.
My lord.
Zamwang, yes, Zamwang side and Byberry side, close bracket. Number 2, wearing course, within brackets, mastic, asphalt, is it?
Asphalt.
Asphalt, close bracket. Then number 3, protective and finishing works, within brackets, painting. Number 4, load testing of bridge superstructure. The full stop. Then the learned counsel for respondent number 1 submits that since the minor works are still remaining, the respondent number 1 had written a letter to the chief engineer, PWD, Commer Roads, Mizoram, asking for extension of validity of the contract period up to 15/12/2025. Provide the letter dated 08/11/2025. The copy of the said letter has been produced before the court. Miss New Para, Miss Linda L. Fombal, learned additional AG, prays for time to get instructions regarding the said letter, which was furnished to her only this morning. In view of the above, list the matter after 1 week. That's it.
I seek your lordship's indulgence in mentioning item 3 of part 2. Even though it is listed for 21/11/2025, if this matter can be taken after the winter vacation, lordship.
Item number 11,
3,
item number 3.
part 2.
Part 2.
My lord,
It's been fixed for 21st.
Yes, lordship.
You are for the appellant.
Yes, lordship.
my
So
lord,
council is, yes, you're also present.
since it is a fixed date, I understand that they have a problem. But if we can try to dispose of by this year, because we have suffered a lot due to this pending case.
But you are the respondent, so the appeal is in your, the judgment is in your favor, isn't it?
Due to this pending case, our church building is under lock and key.
Okay, though it's in your favor, the
Yes.
judgment. So what happened? Why have you prayed for adjournment? You're here?
Yes, lordship. I'm having personal difficulty. I'm taking injections in my spinal cord, which it is difficult for me to stand and sit for a long time.
Okay.
I'm under treatment, lordship.
Treatment. Then we cannot insist, you'll have to bear for some time, isn't it? What difficulty? The house is under lock and key. Where are you staying right now?
We used church gathering at primary school at Dinthar.
Oh, this is a church.
Yeah,
Yes,
Not
church.
personal. Then you can continue. It's okay. Okay, it's not an individual person who is suffering a lot, isn't it? So you're using some church and all that. No, you're using the school for the time being.
Yes, but it's a lot of burden for us.
Why? You can
Because
still
we
learn
used
this thing.
to arrange seat each
Good
and
exercise in the morning. It's okay. That sort of person. If it were an individual person who doesn't have a place to stay and renting a place because of that's a different matter, isn't it? Now, why don't you try and settle the matter? It's between a church, is it?
Yes, lordship.
Have you tried to settle?
Not
Go
yet,
to
lordship.
mediation. Go to
as
mediation.
per the instruction I have, they are not willing to.
Then you're not
have
willing
us-
to settlement, then you have to this thing run around a bit for some time, isn't it? Yes.
We have made suggestion to refer it to the mediation also, lordship, which they do not agree.
Then you'll have to wait to tell them the matter's been, anyways, heard Ms. Rosalind Elmar, learned counsel for the appellant, who has prayed for adjournment of the matter due to some medical, due to some health problems. Mr. J.H. Ramne Moya, learned counsel for the respondent, is present and submits that the continuous adjournment of the matter is causing difficulties to the respondents also. This court, however, finds that since the grounds for adjournment is due to the due to the health problems faced by the learned counsel for the appellant, and the matter is adjourned for 2 weeks, 3 weeks.
Yes, 3 weeks, lordship.
My lord,
3 weeks.
again, if we can have a particular date, if we adjourn for the next year, 22nd of January.
Okay, matter is adjourned and as sought for by the learned counsel for the respondent, list the matter on 22nd
Of January.
1, 2026, yes.
Obliged, lordship.
Highly obliged.
But in the meantime, try to come to some settlement. I think we will, but you're not willing.
Yeah, well, we are not willing because we have a good chance of.
No, whether you have a chance of settlement or not, since you're in the church, you are belong to, I don't know which denomination, I have not looked. But you see, you should try and settle instead of saying, I won, and pressing someone down, isn't it? If you can settle, then it's good for all the members.
Yes, lordship.
Try and come to settlement. You could win through settlement also.
Yeah, in the meantime, we will talk to each other, okay.
List the matter on, meanwhile, the learned counsel for the respondent will inquire whether the respondents are willing to have the matter referred to mediation. and will inform this court accordingly in the next week. Okay. Matter may be listed in the next week. Yes, matter may be listed in the next week. Okay. Yes. I'll
Obliged,
make
Lordship.
certain corrections. Don't make it on the 27th January. Cancel that. Okay. Has prayed for adjournment, which is allowed. Okay. However, since the case concerns the premises regarding the church,
Yes.
the learned counsel for the respondent may get necessary instructions whether the respondents are willing to have the matter referred to mediation. Okay, then list the matter in the next week. Find out what. If they're not willing, then we'll list it on the 27th. Okay, then you can cancel the previous 27th January and all that. Huh? Yes.
I know.
Obliged, Lordship.
For motion, item number 1.
Yes.
May I please, Your Lordship? My Lord, the petitioner herein is a retired employee of Mizoram Cooperative Apex Bank Limited, my Lord. He was retired on superannuation pension on 30/4/2021. And thereafter, at the time of his retirement, my Lord, he was holding the post of AGM. And thereafter, he was re-employed for the next 3 consecutive years as a consultant on tax development sale. And my Lord, he had been served with a so-called notice on 2024 in respect of one loan which was sanctioned back on 2005 and 2006, wherein he was alleged to have committed irregularity and misconduct in sanctioning loan amounting to rupees 7 lakhs. And accordingly, my Lord, the impugned order dated 30/4/2025 was imposed upon the petitioner, whereby
Penalty.
a penalty for recovery of pay from the petitioner was imposed to liquidate the said loan with its interest. And accordingly, my Lord, from his savings bank account at Dolphy branch, my Lord, they have made overdrawn withdrawal of rupees 16,76,737 rupees. And accordingly, the same was repaid by diverting his monthly pension amounting to rupees 35,000 for repayment of the said overdrawn withdrawal, my Lord. He has been maintaining 2 savings bank accounts. Those 2 bank accounts were freeze, including the fixed deposit. Now he has left with no income, my Lord, and no savings accessible. And in view of the procedure adopted by the respondent authority, my Lord, they have not adhered with the provisions of the Staff Service Amendment Rules 2023 while imposing the penalty as well as during the inquiry, my Lord. There was no appointment of inquiry officer, no appointment of presenting officer, and he was also not afforded the opportunity to engage defense assistant.
Okay, so you're challenging the procedure, isn't it?
Yes, my Lord, as well as the impugned penalty, my Lord, 30/4/2025. As per the
Procedure in which the impugned penalty was made, order dated 30/04/2025.
yes, my Lord. In
So
fact,
we'll
my
leave
Lord,
it at that.
there was no inquiry at all.
Okay.
Once so-called notice was given, I made a reply and followed by the impugned order.
Okay, we'll issue notice. Let's see. Heard Mr. Victor L. Rante, learned counsel for the petitioner, who has filed an instant writ petition under Article 226 of the Constitution of India for issuance of the appropriate writ or order to the respondents by assailing the order dated 30/04/2025, wherein a penalty of recovery of pay from the petitioner was made without following the procedure prescribed under the, where's that?
Staff Service Amendment Rules
Where is it?
2020. It's in second page of the synopsis.
Okay, under the staff service, within brackets, amendment, close bracket, rules 2020. We'll stop. The learned counsel for the petitioner submits that the petitioner was only issued show cause notice dated 28/02/2024, wherein he was alleged to have committed gross irregularity while sanctioning loan amount of rupees 7 lakhs while he was functioning as the branch manager of Saiha branch during the year 2005 and 2006. Full stop. Thereafter, the petitioner had submitted his reply by explaining the circumstances and stated that he had not committed any misconduct or irregularity. Comma. However, the respondent authorities had passed the impugned order dated 30/04/2025 without following the proper procedure thereafter. Stop.
My lord, one more point. After the passing of the impugned order, I have preferred statutory appeal, which I submitted on 17/7/2025.
Okay. The respondent authorities have also not considered the statutory appeal filed by the petitioner to the concerned respondent authority in his favor. Full stop. Aggrieved, the instant writ petition has been filed. Yes. Issue notice to the issue notice of motion, okay, to the respondents to registered
My
post
lord, they have.
with AD.
I have been informed that they have standing counsel, Mr. Cyril Fagzola, on
But
behalf of
whether
this.
he accepts or not, yes, are you going to accept notice on their behalf?
I have an interim prayer. This matter may be taken up.
Issue notice
So,
to the respondents. We'll stop. Okay. Then Mr. Asil Al Fagzola, learned standing counsel for the respondents, accepts notice on behalf of on their behalf. No need to issue formal notice. Requisite copies of the writ petition to be duly furnished to the learned counsel. Yes.
My interim may be considered, my lord, at the earliest.
The learned counsel for the petitioner has also prayed for an interim order for staying of the impugned order dated 30/04/2025. Stop. This court finds that this prayer for interim order will be considered in the next stage after the learned counsel for the respondents, the learned standing counsel for the respondents gets necessary instructions. List after,
My lord, can we have the hearing on the interim on next week, my lord?
okay, list after 1 week for a hearing on the prayer for an interim order. Yes.
Deeply obliged.
For admission, item number 2.
Yes.
Yes, Your Lordship, I'm representing the respondent number 6 to 9. And I'm seeking another 2 weeks' time, Your Lordship, to file my affidavit.
For respondent number 1 to 5, similar prayer.
Why? What happened? Have you the same contacted the concerned?
Yes, Your Lordship.
Which department has been
Deputy Commissioner Longley.
the deputy commissioner? So have you contacted the?
Yes, Your Lordship, they
concerned?
are preparing. They are
Okay,
preparing
yes.
and
Miss so and so Is your name there in the cause list?
No, my lord.
Appears on behalf of her senior, Mr. C. Laramzawa, learned senior counsel for the petitioner, along with Ms. Vane Isyami, learned government advocate for respondents number 6 to 9, and Ms. Baby Laldin Zwali, learned counsel, appearing on behalf of Ms. Zairam Sampui, learned CGC, for respondents number 1 to 5. Stop. The learned government advocate submits that the state respondents are in the process of preparing the Parawise comments and has prayed for further date to file their counter affidavit. The learned CGC has also prayed for more time to file their counter affidavit. In view of the above, list the matter after 3 weeks.
Obliged.
Item number 3.
May it please your lordship, I'm appearing on behalf of the state respondents number 1 and 2, 1 to 5, your lordship. Your lordship, we are yet to file the affidavit in opposition. Therefore, if 2 weeks time may be kindly be granted, your lordship, to file the necessary affidavit.
Okay, Ms. So-and-so appears on behalf of her senior, Mr. Silal Ramzawa, learned senior counsel for the petitioners. We'll just make it the learned counsels for the respondents have prayed for further time to file their counter affidavits. That, in view of the above, list after 3 weeks.
Item number 4.
My Lord, I think the ID card has been returned from the respondent number 3. Your Lordship.
Yes, Your Lordship, with regard to this matter, Your Lordship, regarding the deduction of cess, 15% cess. Recently, there is a judgment regarding that cess, and it upheld the deduction of cess. So, if I
What
may
is
be
the
allowed
judgment?
to submit that judgment in order, Your Lordship.
Judgment made by the division bench.
Division bench.
Okay.
My Lord, in that
What is the
matter,
judgment?
I'm not aware, my Lord.
He's not aware, so we'll give you next time. This
And,
thing
my Lord, they can file an affidavit to that effect. Just submitting right now and
a copy of the judgment, you give it to both, but then you study the matter, isn't it? Mr.
yes.
What, huh? Mr. Jonathan L. Silo, learned counsel for the petitioner, is present, along with Ms. Vane Isyami, learned government advocate for the state respondents, Ms. Baby so-and-so, appearing on behalf of Ms. Zairam Sankwe, learned CGC, for respondents number
8 and 9.
8 and 9, and Mr. Samuel L. Sankwe, learned counsel, learned standing counsel for respondents number 5 and 6, full stop. The learned government advocate submits that recently the division bench of this court had passed an order in a similar matter regarding the deduction of cess from the awarded amount granted to the petitioners. Full stop. The learned government advocate has produced the copy of the judgment of the division bench of this court in WA 16/2024, dated 03/11/2025. Stop. Mr. Jonathan L. Silo, learned counsel for the petitioner, submits that he was not aware of the said judgment, and since the copy of the judgment has been furnished to him this morning, he has prayed for adjournment of the matter. In view of the above, this the matter. When do you want it? Tomorrow?
my Lord,
In the next week?
in the next week.
In the view of the, this the matter in the next week. Okay, then let's see. I've not seen the judgment also.
Item number 5.
My lord, this matter relates to Bagarot compensation case. Now, as permitted by your lordship, we have filed an affidavit in compliance of Justice Service on 10/10/25 to the private respondents. Now, in the affidavit, my lord, we have stated that the respondents, they have refused to accept the notice which was served to them. And there is an acknowledgement, my lord. Acknowledgement written in each of the notice.
So who are they? Only private respondents?
Yes, my lord. The department are represented by government advocate in this case.
This is 136 days. What is the matter about?
My lord, this is a case which was passed by the Land Reference Court at Scholarship with regard to Sherkhantu Bagarot relating to Land Acquisition Act 1894. What was passed by the Land Reference Court? We have
You are
challenged
representing the,
PWD, my lord.
okay, PWD. So if the, now you are representing the PWD, who is the state government.
Yes, my lord.
And then how can the government, this thing, you're representing whom?
They are
Government
impleaded.
advocate.
They are
Yes,
impleaded
Your
as
Lordship.
11 and 12, my lord.
Why have you impleted them,
Yeah,
11
my
and
lord.
12? Same government,
Correct. My
so
lord,
one department of the government impleading the other.
I have been appointed only for this PWD. That's why.
No,
That is really-
but then why have you made the government a party when you are the government?
Yes, correct. Yes.
So I'm
They
not
are
under-
made as only pro forma, my lord, in this case.
Wait, represent the Public Works Department. So how have you impleted the state? You don't have to impede them as what?
Only pro forma, my lord.
No, so now the Land and Revenue Settlement, this department, they must be also aware of this, and the district collector.
In the trial court, my lord, they have filed a separate written statement in some cases, and they have also adduced evidence separately.
And you're unhappy with the evidence or what?
No, we are unhappy with the award passed by the Land Reference Court. So,
So I have a feeling that the appellants should also be respondents number 11 and 12.
yeah, maybe I've done wrong on that part because I was
Isn't it?
appointed
Huh.
only for the PWD. That's why we have made them as a pro forma. But they can be interposed as a appellant also in this case if the court permits.
No, then you'll have to make the correction because
we-
it is,
Or we can delete them as the
yes.
pro forma respondents. With your lordship permission, we can delete right now. They are not necessary because they were.
Do you have anything to say here?
No, Your Lordship. Since the appeal is from the state.
No, from the state, so the government cannot stand on the other side.
The problem with our appointment is that we have been appointed only for that.
So even then you don't have the PWD department. So, but then PW department will also have to, it should be in consultation with the Land and Revenue Department and the collector.
Yes, Manu. It is our understanding that since we are only engaged by the state on behalf of the PWD, that we cannot represent the other respondents.
So you don't make them a party?
Yeah,
You don't-
then, with your lordship permission, we can delete them from the parties.
Anyway, where's that affidavit showing that the private respondents are not willing to?
We have submitted the affidavit on 10/10/25, my lord. Your lordship will see
Where's the
Annex-
correspondence file? Oh, wait, a separate file, a separate C file, yes. So what is the position now?
The position is that, my lord, the current status is that some landowners have filed an execution petition before the Land Reference Court. Now that execution proceedings has been stayed by this honorable court. Some of them, instead of coming to this honorable court representing the respondent, they have gone straight to the executing court. That is what I understand. Some
But
landowners-
this is for this in limitation, isn't it?
Yes, my lord.
So that means there's another case pending, because when this is for condonation of
This
a
is
delay of so many days.
This is
then-
against the judgment and award dated 17/12/2024, passed by the learned judge, Fast Track Court. Now, the landowners have gone to the reference court, pleading that this judgment and award has not been complied with. So they have filed an execution petition,
No, which was stayed by whom?
which was stayed by this honorable court.
Where? In another case, there's another WPC, is
No,
it?
it's not WPC. There is an appeal against that execution order, which stayed the proceedings. That is a separate proceeding, Malo.
Oh, it'll be separate.
Now this
because
is a separate
here
proceeding.
this is completely separate
Yes,
because
yes,
this
yes.
is for condonation of a delay. So
Correct.
there cannot be an order here.
Yes, there is a separate RFA against that execution order. Now this case is different.
But concerning the same, the same stretch of land.
Yes, they have filed execution petition, some of the landowners,
Okay, but the petitioners are not the same.
not the same. Some cases are there. I have the information that, my lord, there are 5 execution petition filed.
So none of the petitioners are involved in the execution petition, is
No,
it?
LA Appeal 4 of 2025 is there. LA Appeal 5 of 2025 is there. LA Appeal 6, 7, and 8.
Okay, so the petitioners are different there. Is it not the petitioners, the appellants are different, is it?
In LA Appeal 4, 5, 6, 7, and 8, execution petition is pending. Here it's there, my lord.
But LA appeal number 5, 6, and 4, execution is pending, but the LA appeal has not been, condonation has also not been allowed.
Yeah, it has not been admitted yet. Now we are stuck with that notice, my lord.
I don't know how you can get these stay. Anyways, heard Mr. C. Lal Faghzwala, learned counsel for the applicant. Also heard Ms. Lalnun Louis, learned government advocate, who submits that the instant appeal is been filed by the state of Mizoram / PWD department, and therefore, being the government advocate, he does not have anything to say in the matter. Full stop. The learned counsel for the applicant / appellant submits that the revenue land settlement and revenue department and the deputy commissioner, is it?
Yes, sir.
Have been
District collector.
the district collector have been arrayed as respondents number
11 and 12,
11 and 12
pro forma.
only as pro forma respondents, since the appeal has been preferred by the PWD department. Full stop. New para, the learned counsel for the applicant further submits that though they had made an attempt to serve notice upon the private respondents number 1 to 10 through dusty mode. However, the private respondents have refused to accept the notice, and affidavit to that effect has also been filed. So, on considering the submissions made by the learned counsel for the applicant, this court find it appropriate to proceed with the interculatory application for the condonation of delay of how many days?
136 days.
136 days in preferring the connected appeal in LA Appeal number 4 of 2025. So, yes, what is the reason for the delay?
My lord, my grounds are at page 5. Starts from page 5. We have received the impugned judgment and order dated 17/12/2024. It's by the personal branch of the Commissioner and Secretary PWD on 19/12/24, by receipt number 543. That is after 2 days of the pronouncement of the judgment and order dated 17/12/24. That as soon as the applicant came to know about this impugned judgment and order, the same was forwarded and received by the PWD Technical Government of Mizoram on 20/12/2024, via receipt number 1960. Thereafter, the Undersecretary to the Government of Mizoram Public Works Department had thereafter conveyed the said judgment and award dated 17/12 in LA case number 16 to the Office of the Engineer-in-Chief PWD Mizoram on 20th December 2024 for further necessary action, and it was received by them on 27/12/2024. It may be mentioned herein that the Government of Mizoram was closed for winter and Christmas holidays for the following days, 24/12/2024 to 26/12/2024, and 31/12/2024, dated 1/1/25 and 2/1/25, whereas the Honorable Guwahati High Court Azol Bench was again open for the year 2025 with effect from 13/1/25. The period between 28/12/2024 to 30/12 and 14/1/2024 and 4/12/2024 was used to make deliberate decision to file an appeal. It may be fair to mention that since no legal officer were posted in the office of the ENC.
Anyways, it's you have explained, isn't it?
My lord, my grounds starts from page 5 to
Anyway, the learned counsel for the applicant submits
16.
that the grounds for the delay of 136 days have been explained in detail at para 3, is it?
5,
Para 5.
5 to 16. Page 5 to 16.
No, para,
No,
at
page
para
5 to
3, we cannot say page 5, at para 3, okay?
Yes,
Then within brackets, Roman 1, okay, small, in 1 to
25.
25, Roman 25 small. And that the main grounds was for the delay was, and was due to the steps taken by the concerned appellants for consultation and coming to a decision to file the appeal through the appropriate procedure. Full stop. He further submitted that there was further delay since the applicants had also tried to negotiate and settle the matter outside court with the private respondents regarding the amount of compensation, which, according to the appellants, was too high and not as per law. He further submitted that further delay was caused due to the closure of the High Court during the winter vacation, and which two vacations? I've seen one, winter vacation and the summer vacation, is it? Where's the vacation part?
Government vacation, my lord. Here at page 7, your lordship will see at page 7, Christmas holidays.
Okay, due to the winter vacation, and also time taken to engage a different counsel who is not the government advocate to take up the matter. So, then new para, this court has perused the explanation given by the learned counsel for the applicant at para 3, then Roman 1 to Roman 25-25, and finds that the learned counsel for the applicant has given a satisfactory explanation for the delay of 100 and so days. How many days?
136.
136 days. Delay in filing the connected appeal against the judgment and order passed dated 17/12/2024, passed by the learned judge, fast track court, Colosseum district in LA case number 16 of 2015. Accordingly, this court find it fit to condone the delay of 136 days, which this court finds is not due to negligence or laches on the part of the applicant. IA number 125/2025 thus stands allowed and disposed of. Now, in the main LA appeal, on the disposal of IA number 125/2025, allowing the condonation of the delay, this court has heard the learned counsel for the appellant, Mr. C. Lalfanzola, learned counsel, who submits that there are sufficient grounds for setting aside the judgment and order dated 17/12/2024, passed by the learned fast track court, same, okay, Colosseum in LA case number 16 of 2025. Since the learned counsel, court, what was the reason?
My lord, one of the reasons is that the learned reference court has passed the
The
impugned
learned
judgment.
reference court, had
Judgment and award on the basis of the award which was superseded by the revised award number 3 of 2014. It has granted the award as per the earlier award which was cancelled and
Since the
superseded.
learned reference court had passed the award based on a superseded award, whereas the learned reference court should have passed the award based on the
Revised award
revised award dated,
number 3 of 2014,
okay, award dated
7/8/2018.
17,
7/8/2018.
okay, 07/08, 2018.
18.
Then appeal is admitted. Issue notice to the respondents. Again, you'll have to issue fresh notice, okay?
My lord, your lordship may permit us to issue notice to newspaper publication.
Okay, through registered post with AD, made an attempt first with AD. Within 3 working days, returnable by 3 weeks. Now, I don't know whether the state, Ms. Lalnunlui, has to be made the same respondent or not. I'm a bit confused in that matter. Find out.
Yes, Your Lordship.
Is it appropriate for them to be the made a respondent even pro forma? Because even if they have nothing to say, the appeal is against them.
Yes,
So
my lord. This is a demerit of
whe-
being
whether
a private
it
lawyer.
will be appropriate or not, you tell me. Will
Your
it be
Lordship, there are certain
appropriate?
Supreme Court cases wherein the Supreme Court has already repeatedly said that the department cannot file cases against the assisted department. So, Your Lordship, in this case,
I don't think
since
so.
we do
You'll
not
have to
have-
strike off this thing. I don't
yes, Your
think
Lordship,
it's
if
appropriate.
yes, Your Lordship, if the state respondents can be struck off from the list of respondents.
My lord, your lordship can suo moto strike them off from the party.
The learned counsel for the learned government advocate. No, and before that, Miss Lalnunlui, learned government advocate, submits that the appellant has made the Land Revenue and Settlement Department and the District Collector, Colossi, as respondents number in the appeal, 11 and 12.
11 and 12, Your Lordship.
11 and 12. However, the state respondents, however, the state, okay, cannot be make the respondents in the instant appeal. She therefore prayed that their names may be struck off from being arrayed as respondents number 11 and 12 in the instant LA appeal. Stop. Mr. Seal Al-Fagzola, learned counsel for the appellant, has also prayed that the names of respondents number 11 and 12 have been mistakenly included in the said LA appeal, and prayed that the respondents number 11 and 12 may be struck off. Stop. In view of the above submissions, this court finds it appropriate to strike out the names of respondent number 11 and 12, registry to do the needful. List after 3 weeks.
Obliged.
Much obliged, Your Lordship.
Item number 6.
My lord, these are all related cases. We have filed
Same.
yes, an affidavit of compliance on 10/10 to respondent 1.
How many days? Same.
The days would be different. Here, 140 days.
Okay, in item number 6, same order, only thing is number of delays will be 140.
140 days.
And Your Lordship, the state respondents are 4 and 5 in this.
Okay, 4 and 5. Otherwise, everything is the same?
Yes,
Your
madam.
Lordship. Same prayer.
But your paragraphs?
Yeah, paragraph will be different.
Okay, wherever I've put paragraph number 3, it will be paragraph number, oh, same.
3, 1, 2.
Paragraph number 3, 1 to, is it 25?
and 24.
1 to 24. Are you understanding? 3, 1 to 24, where we've made it 25. 25, that Roman, this thing in small. Huh? Otherwise, rest will be the same. And respondents will be
4
private
and 5,
respondents
Lordship.
number
4 and 5.
4 and 5.
Yes,
Okay, not 1 to 10, but 4 and 5. Then, again,
Item number 7.
then IA number 127 of 2025 stands allowed and disposed of. Yes. Then the next one is
In the LA appeal, madam.
LA, again the same order. Only thing is the respondents, state respondents will be,
43 and 44, Your Lordship.
no, we are still dealing with 6.
Yes, Your Lordship.
Item number 6, you will be respondents number
4 and 5, Your Lordship.
4 and 5. Okay. Now, 7, then, and 7. Come on, give me first. Condonation of delay of how many days?
Item 7.
Yes, item 7.
A condonation of delay, again 140 days.
Yes, madam.
Paragraphs will be 3, again 24, same order. How many this thing, applicants are there? No, how many respondents?
43 respondents are here.
44.
And the state, 44, sorry. The state are 43 and 44. Private respondents are 1 to 42.
1 to 42 private respondents. State respondents is 43 and
44.
44.
44. Okay, they are to be struck off for that part. Yes.
Item number 8.
So you have to look, okay. Look at the pages, see the order, see how many have. Here,
Here, my lord, ID card for respondent number 1, 2, 3, 5, and 6 has returned
Yes.
back. And ID card for respondent number 4 is awaited, my lord.
then we'll have to wait for this thing,
Yes, my lord.
for them to be duly represented.
Yes, yes.
Now, this is item number 8 here. Heard Mr. Asil Al-Fagzwala, learned counsel for the applicant, who submits that AD card upon respondents number 1, 2, 3,
5 and
5
6.
and 6 are returned, served and returned. Full stop. While AD card upon respondent number 4 is still awaited. Full stop. It is seen that none appeared on behalf of respondents number 1, 2, 3, 5, and 6. Full stop. We may await for the said respondents to be duly represented. List after.
Your Lordship,
3
if I may
weeks.
make, if the similar prayer for respondent number 7, 8, Your Lordship, that is the state respondents in this case.
Yes, then in the IA itself, we will say that Ms. So-and-so, learned government advocate, submits that the Revenue Department and the District Collector have been arrayed as respondents number 7 and 8 in the instant IA. However, since the Revenue Department and the District Collector are the government, are the departments under the state government. Their names may be struck off from being arrayed as respondents number 7 and 8. Full stop. Then Mr. Silal Fagzola, Learned Counsel for the applicant, submits that the respondents number 7 and 8 have been mistakenly arrayed and prayed that their names may be struck off. Accordingly, the names of respondents number 7 and 8 are to be struck off registry to do the needful. Okay. In fact, I think we will make this on all the IAs also.
Yeah.
Yes, Your
And
Lordship.
in the RF. We will have to look at it. Then that is number 8. Then
Item number 9.
My Lord, with item number 9, ID card for respondent number 1 to 31 has not returned back. We can await for the return of the ID
okay, you
card.
have not paid for Dusty here.
No, I have not paid for that fee.
Okay, Mr. Silal Fagzola, Learned Counsel for the applicant, is present and submits that AD card from respondents number 1 to 31 is still awaited. Return of AD card, okay, from respondents number 1 to 31 is still awaited. In view of the above, we may await for return of AD card from
Lordship.
respondents number 1 to 38. Then full stop. Then the learned Ms. Lalnoon Louis, Learned Government Advocate, okay. Here same order it will be, but respondents number 32 and 34.
33, Your Lordship.
Oh yes, 32 and 33. Okay, that is Revenue Department and District Collector. Then the same order as the previous order. In
If
item
we may be
number 8.
allowed to take newspaper publication in the meantime.
We'll wait after 3 weeks. Let's
Malam,
wait
malam.
after 3 weeks.
Item number 10.
All of them are your cases, huh? 10. What is 10?
ID card for respondent number 1 has returned back on 13/11/25
Not represented.
without signature, my Lord. It has returned back without signature.
What is the meaning?
That is what
Then you
It
issue
is what
fresh,
I've seen in the notes.
notice and see what's happening. How many respondents? 1 to 3, is it?
1 to
Only
3.
one.
Yeah, only one is the
2 and
private
3.
respondent.
2 and 3 is the government.
Yes, my Lord. We can take justice
fresh,
service, my Lord.
okay, heard Mr. Silal Fagzola, Learned Counsel for the applicant, who submits that he may be allowed to take steps for service of notice upon respondent number 1, since AD card upon respondent number 1 is returned unserved. In view of the above, this court finds it fit to allow the Learned Counsel for the applicant to serve notice upon respondent number 1 through dusty mode, and affidavit that to that effect is to be filed accordingly, list after 3 weeks. Full stop. Then same, Miss Lalnoon Louis, Learned, okay. Then
Yes,
there
Your
will be respondents number 2 and 3 to be struck off. Same order.
Item number 11.
Not here, ID card for respondent number 1 to 8, 10 and 11 are received on 13/11/25. And ID card for respondent number 9 and 10 are awaited.
9 and 12.
9 and 12, sorry.
Heard Mr. again. It is seen that AD cards upon respondent number 1 to 8, 10 and 11 were received on 13/11/2025. However, none appeared for the said respondents. we will await for the respondents to be duly represented while awaiting for return of AD card from respondents number 9 and 12. So, then Ms. Lalman Louis, same order, only thing, so it will be 13 and 14.
Yes, Your Lordship.
Then list after 3 weeks.
Obliged.
Item number 12.
AD card for respondent number 1 to 8 has no return date, my lord, in this case.
Okay, heard so and so and so. We may await for return of AD card from respondents number 1 to 8. List after 3 weeks. Then Miss so and so. Then it will be 9 and 10.
Much
Deeply
obliged, Your
obliged.
Lordship.
Part 2 hearing, item number 1.
Yeah,
What's
please,
the matter
Lordship.
about?
My lord, I'm for the appellant. Facts of the case in brief is that, my lord, the respondent as plaintiff filed the civil suit number 114 of 2015 before the learned senior civil judge. Facts of the case in brief is that the plaintiff appeared in the HSLC exams conducted by the defendant, that is the MBSE, Mizoram Board of School Education, in the year 2015, my lord. And result was published and he was declared to be passed in distinction with letters marked in all the subjects except science. Well, he was given only 65 marks. And he applied for re-evaluation and his marks improved to 82, from 65 to 82, my lord. And according to the plaintiff, he had applied for his answers paper for inspection through RTI, but the defendant refused to entertain the same. When the plaintiff sought for admission to St. Paul's Higher Secondary School, he was flatly refused admission in science stream because of his marks in science. That is 65 only. And admissions were closed before his evaluated marks were given to him.
This
He
is
had
which year? Which year? This is in which year?
That was in 2015, my lord.
15, way
15,
back.
2015, my lord, yes. In fact, the matter has been pending for quite some time. Because of one reason or another, we could not have a hearing on it. So, my lord, there is the facts of the case in brief. The I would like to take your paper book. I'm reading the paper book. At page one of the paper book is the plaint filed by the respondent plaintiff, my lord. It is not very long. I'm reading with lordship permission. The plaintiff, number one, paragraph number 1 is the introduction. Plaintiff Lalsan Hima Rentlei is a minor and is represented by his father, R. Ming Moya. The permanent address so and so are given there. Paragraph number 2, that the defendant number 1, the MBSE, Mizoram Board of School Education, is an autonomous body which was established in the year 1975 through the Mizoram Board of School Education Act. Its primary function is to conduct state-level high school living certificate exams and higher secondary school living certificate exams. As specified in its website, the chairman of the Mizoram Board of School Education, through whom the Mizoram Board of School Education is being sued, is a whole-time officer appointed on contract service by the government on terms and conditions agreed to between the person selected and the government. These are all formalities, my lord. I may skip. And I'm coming to paragraph number 3 on page 2. The class 10 or matriculation exam is perhaps the most competitive examination in Mizoram. Thousands of students in Mizoram appear in this examination every year. That is also not very important. I'm taking your lordship to paragraph number 4. That the plaintiff Lalsanhima Renthe is one such candidate who had appeared in the matriculation examination conducted by the defendants in the year 2015 under roll number so-and-so, registration number so-and-so. Being a competitive student, he had always been outstanding among his peers, aspiring to get admitted in what is widely regarded to be the best school in the state, namely St. Paul's Higher Secondary School, to take up science stream there and ultimately pursue MBBS in one of the nationally reputed institutions. He spent a huge amount of his time preparing for the said examination so as to secure a desirable mark that would ensure his admission and pursue science in the said school. A huge amount of money was also invested in the process of preparation for the said examination, whereby he was admitted to a boarding school in Aizawl. On dated 27/4/2014, the result in the said examination was declared. Not surprisingly, in the said examination, he was declared to have passed in distinction with letter marks in English, Mizo, mathematics, and social sciences. In fact, in maths, he was awarded 98 marks out of 100. However, to his surprise, he was awarded only 65 marks in science, which would suggest that he would have no chance of making it to St. Paul's Higher Secondary School, wherein he wanted to take up science stream in his higher secondary education. Being extremely surprised and unable to accept the mark that was given to him, the plaintiff, soon after the results were published, applied for a re-evaluation of his mark in science. Paragraph number 5, that white letter number so-and-so, dated 1/6/2015, the plaintiff was informed by the defendant number 3 that his marks were re-evaluated and that after re-evaluation, it was found that there were grounds for a significant change in his result. Being so directed through the said letter by the defendant number 3, the plaintiff, through his father, approached the defendants. The plaintiff's mark in the said paper was then substantially improved from 65 to 82 marks. Thus, there was a difference of 17 marks between the mark that was initially given to him and the mark that was subsequently given to him after it was re-evaluated. However, still unsatisfied, the plaintiff, through his father, wanting to inspect his answer paper, sought to obtain it through RTI. The defendants not only refused to entertain the application, but they were not even willing to receive the application. All these go to show that there was, in fact, a major error in the calculation evaluation of the plaintiff's mark in science, and that this can be of no other reason but because his science paper was negligently marked, evaluated, and calculated by the defendants. It is thus submitted that, in doing so, the defendants had breached the duty of care which they owe to the plaintiff. Paragraph 6. That the direct effect of the negligence or breach of duty on the part of the defendants was that the chances of the plaintiff taking up science stream in St. Paul's Higher Secondary School was completely obliterated. In fact, he had applied for an admission there and he even appeared for the interview on 6/5/2015. However, he was flatly refused admission in science stream because of the mark that was awarded to him. By the time his marks were evaluated and improvements made, admissions in the said school were already concluded, and therefore the chances became completely frustrated. Hence, he was forced to secure admission in Sercon Higher Secondary School, which is not of the same stature as St. Paul's Higher Secondary School in terms of reputation, rigor, and the way education is imparted, the exposure and the outlook that one receives, and also the competition that exists in each of the said schools. St. Paul's Higher Secondary School, being the most coveted school in Mizoram, getting admitted there would mean competing with the highest ranking science students of the state and getting the best possible exposure in Mizoram, which would not be so in Sercon Higher Secondary School. Thus, it is submitted that the plaintiff had clearly suffered injury because of the simple fact that the defendants had breached their duty of care towards the plaintiff, for which the defendants are liable to the plaintiff. Number 7, that it is also submitted that the plaintiff not only suffer injury in the form stated above, but the plaintiff also suffer much mental pain, shock, suffering, agonies, hardships, and inconvenience, which had for a long time resulted in sleepless nights and frustrations, which he continues to suffer even today. In short, it may be submitted that the entire incident and experience has caused a very negative impact to the plaintiff. That being extremely aggrieved, the plaintiff, through his counsel, served a 2 months notice as per Section 80 of the CPC on the 17/7/2015 in the office of the defendant, wherein the following reliefs were claimed. Number 1, for payment of rupees 3 lakhs to the plaintiff for the injury and the may suffer as a result of the breach of duty by the defendants. Number 2, for payment of rupees 30,000 along with an interest 12% per month from the date the notice is served for all the expenses incurred by the plaintiff in traveling and staying in Aizawl and other expenses incurred in connection to the re-evaluation of the answer paper. For payment of rupees 2 lakh to the plaintiff as compensation for pain, shock, suffering, hardships, and inconveniences suffered by the plaintiff. For payment of rupees 5 lakh as punitive damages, and for payment of rupees 40,000 to the defendant for the legal expenses incurred. However, rather than fulfilling the reliefs claimed by the plaintiff, the defendant number 2 made a reply to the counsel for the plaintiff through the impugned letter number so-and-so, stating the grounds for which they refused to grant the relief. Hence, being so aggrieved, the plaintiff has been left with no other option but to approach the Honorable Court for the ends of justice. Said notice will be read out there
Okay, so
later.
that's the main thing, huh? Then,
My Lord,
what is the judgment?
the judgment is found at
In your writ, what did you say in your WS?
WS, my Lord.
statement?
Yes, I'm reading the WS.
You deny, is it?
We have denied everything. My Lord,
Anyway, so you denied, so what is the judgment? What is the court, what's the finding?
no, before that, my Lord, I'm reading the WS, not all. Our WS is rather long, but only the points which are to be highlighted. At WS is found at page 15, page 15 of the paper book. I'm reading from page 16. Page 15 is the course title. Page 16, preliminary objection, my Lord.
Okay, that's
This
the
not-
maintainability, believe that? Are you not? it's not
Number 4, I'm
challenged,
taking
right?
to a lot to para 4.
Oh.
That the suit is bad for misjoinder of the necessary parties and non-joinder of parties, such as St. Paul's Higher Secondary School, Aizawl. Hence, the same is liable to be dismissed on this ground alone. As per the plaint submitted by the respondent plaintiff, he applied the for admission in the St. Paul's school for +1 science stream, but the school has not been made implemented as one of the parties.
Okay.
Not only that, no document has been annexed along with the plaint. No documents and not implemented as a party. So only on his on the submission, the impugned judgment and order was passed.
Okay.
And my lord, number 5 is the plaintiff has made various allegations and claims huge amount of compensation without filing any supporting documents to substantiate his claims. No document, no supporting documents, and no witness apart from his own evidence. No other witness at all. And my lord, para 8, I'm taking to your lordship to para 8 of my written statement that the contents of para number 2 are partly admitted. It is true that the Mizoram Board of School Education has been conducting state levels exams as per the MBSE Amendment Act 2014, Section 11 reads, the board shall have, subject to any general or special order of the government, the provision of this act and any rules made thereunder, the power to regulate, supervise, and control school education in Mizoram. Section 11.2 also states that the powers and duties of the board is to conduct and supervise so and so, my lord. And we have also at Paraten, my lord, I'm taking a lordship to Paraten.
Yes, Paraten.
The defendants admitted the affirmance of the plaintiff in Para 4 to the extent that he had passed in distinction and secured letter marks in 4 subjects, that he was awarded only 65 marks in science, and that he had applied for re-evaluation as per section 35(1) of the bylaws. That is the provision we have for re-evaluation, my lord. On the subject, re-evaluation, who stated that any candidate who has appeared at the examination of the board may apply to the secretary of the board for re-evaluation of his answer script. A candidate may, within 15 days of the declaration of the result, apply for re-evaluation of not more than 2 papers by paying a requisite fee as fixed by the board from time to time. We have enclosed a copy of the bylaws also, my lord. And the intention of the said provision is to ensure transparency and accountability, my lord. The defendants admitted the error committed and thus issued a notification dated 29 May 2015 declaring the modification of marks of the plaintiff among the candidates who applied for re-evaluation of marks, my lord. To err is human, as we all know. Error could be committed by anyone, but we have a provision for re-evaluation so as to correct the mistake committed by us. And that is why we have this provision for re-evaluation, my lord. And para 11, the defendants here in the appellants deny. I'm reading from 7 lines of the statement, para 11, my lord, that the defendants, rather than reading the whole thing, because it is repeating the same thing also, that the defendants have never received any application from the plaintiff through his father or anyone else representing the plaintiff for inspection of his answer papers through RTI as contended. Supposing he has filed application under RTI for answer papers, the same was not entertained by the MBSE, presuming.
All that must have been discussed by the learned
My lord, my lord.
court.
He could have filed an appeal also before the appellate authority. Same has not been done. And a copy of the said application for under RTI also has not been enclosed along with this application. I mean, so no documentary evidence at all. Besides this, there is another provision under bylaws, section 34(1) to 5, as seen in Annexure 2, where any candidate could apply to the secretary of the board issuance of a photocopy of his answer scripts without invoking RTI. Without invoking RTI also, it is possible to obtain the Xerox copy of the answer script. The purpose of this section is solely to enable the candidate to personally verify that a thorough assessment of the answer script had been made. The same has not been done. So all these things are done. I mean, we have this provision in order to ensure transparency and accountability in such exams conducted by the MBSE. And on the following page, my lord, page 19, I'm reading from the second line. Under section 28 of the MBSE bylaws 2008, answer books bear fictitious roll numbers so as to avoid disclosure of candidates which are evaluated by approved examiners. Well, section 30 and 31 talks about the head examiners and examiners. Inter alia, the appointment of qualified teacher for such job. Their duties and functions, which is to ensure and monitor uniform evaluation of answer as per model answer and also to ensure strict implementation of the
So you say
marking
that
scheme. My lord.
MBSE took the due care, isn't it?
Yes, my lord. This is what we are trying to show to your lordship.
As per the MBSE bylaws.
Yes, my lord. So all these things are in that connection, my lord.
Yes.
And para 12 on the following page, page 20. I'm reading paragraph 12 on the third line. The plaintiff based his statements on chance and unforeseen eventuality. To be more exact, the plaintiff does not have any supporting documents to show that his application for admission to St. Paul's Higher Secondary School was refused in science stream because of the mark that was awarded to him in science subject, as it could be any other reason, until and unless the same is clarified in writing by the principal of the said school. As for the allegation made by the plaintiff against one of the highly reputed school in the whole state of Mizoram, it is humbly submitted that Serkon Higher Secondary School, which is never known to be in any way inferior to any other school, is undoubtedly one of the best among the schools in existence today. It is not known as to how and why the plaintiff has categorized the Serkon Higher Secondary School to be lower in terms of reputation, rigor, and how education is imparted. The plaintiff has never been authorized to make classification of school by the competent authority at any point of time. As such, all the avowments and submissions made by the plaintiff in these paras are imaginary and without any basis whatsoever. Well, these are all submissions made by us.
Then, however, what happened to the judgment?
And I'm taking your lordship to the judgment. Judgment is found at page 94, my lord. Page 94. I'm reading from, judgment, para 1. The case of the plaintiff as contended in the plaint is that the plaintiff is one of the candidates appearing in the matriculation examination conducted by the defendants in the year 2015 under roll number so-and-so, registration so-and-so. Being a competitive student, he had always been outstanding among his peers and aspired to get admission at St. Paul's Higher Secondary School to take up science subjects. He had spent a huge amount...
So this is this thing, no?
Repeating.
This is the repetition,
My lord,
the
repetition, yes, my
reasoning
lord.
of the court. Issues
and-
frame, just come to the issues frame and the reasoning.
Yes, my lord.
What are the issues frame?
Issues
Page
frames is
96,
whether, number one is whether the suit is maintainable in its present
Okay,
form and
and,
style. Number two, whether there is negligence on the part of the defendant in checking the answer sheet of the plaintiff. Number three, whether the plaintiff suffered loss as a result of negligence. Number four, whether the plaintiff is entitled to the relief claim. So, coming to para 9, the plaintiff alone adduced evidence and exhibited 16 documents to prove his pleading, my lord. The plaintiff alone adduced evidence. So the defendant examined David Lomkima, Director, Academic, MBSE, and Michael Larin Moy, Academic Officer, MBSE, and exhibited documents so-and-so. And Sarah Lalengzami Pachuo was examined as court witness. So number 10 on the following page, page 97. I have heard learned counsel for the plaintiff and learned standing counsel for the defendants and have also perused all the materials available on record. I have also given any anxious consideration to the submissions and accordingly my issue-wise findings are as under. Issue number 1 is preliminary issues. I'm reading the issue number 2. whether there is negligence on the part of the defendant in checking the answer sheet of the plaintiff. Para 2, the learned counsel for the plaintiff has urged that the error in the calculation, evaluation of the mark in science paper was due to negligence and breach of the duty of care to care. Learned counsel for the plaintiff places reliance on Rajkot Municipal Corporation versus Manjula bin Jayantilal Nakum and others, reported in 1997, volume 9, SCC 552. Per contra, the learned counsel for the defendants has argued that there is no negligence on the part of the defendants, as they have taken utmost care to appoint competent teachers.
Anyway, so mistake was made, whatever, so mistake was made in the marks, isn't it? That's
Right, my lord.
admitted.
Right, my lord. And the same was, in fact, on re-evaluation, it was rectified, my lord.
So 98, page 98, so the court has relied on this judgment, isn't it?
Yes.
What is this?
The
President?
president,
Board,
yes. In the case of President Board of Secondary Education, Orissa, and another versus the Suvankar, Honorable Supreme Court has observed as under, that is, ultimately, it is the board which has to ensure that the correct mark sheet is issued to the candidates, since candidates who appear at the high school certificate are of tender age. If by mistake, the board indicates to the candidates incorrect marks, it is bound to have adverse effect on the mind of the candidates of tender age. Therefore, it is imperative on the part of the board to ensure that a faultless mark sheet is issued to each candidate. Errorless mark sheet is issued to each candidate. The plea of the computer firm that considering the large number of candidates, the mistake is not serious, has no substance. The computer entries are made to ensure accuracy and to do away with defects, which arise from manually recording of marks and to ensure accuracy. The assistant examiner and scrutinizer appear to have taken their jobs casually, unmindful of the consequences which result from their negligence acts. In the facts and circumstances of the evidence on record, it is seen that the defendants failed to exercise a standard of care which they ought to do. Accordingly, this issue is answered in affirmative and decided in favor of the plaintiff. My lord, in this connection, I would like to make some submission. The ruling passed by the Supreme Court is not similar to the present case. For example, in the Board of School Secondary Education, Orissa, there is no provision for re-evaluation. Whereas in our case, we have the provision for re-evaluation. Whoever is aggrieved or having complaint against their marks, they can apply for re-evaluation by paying fees. They can apply for that. Accordingly, the respondent plaintiff also applied for the same, and he was given more marks, better marks, after re-evaluating, because the mistake committed by the staff was rectified by applying the re-evaluation.
Yes.
Whereas in the case of the Orissa secondary education, there is no provision for the same. And that is why they had approached they had filed writ petition in the High Court. And the High Court rejected their petition for having no re-evaluation provision in their act. And that is why they reached the Supreme Court. And coming to my lord, issue number 3, whether the plaintiff suffered loss, the case is a result of negligence. It is seen in the plaint and evidence of the plaintiff that his sense of taking up science stream in St. Paul's Higher Secondary School was lost due to the error of marks in science subject. The plaintiff has stated in his deposition that during the interview, the interviewers, after looking at his mark sheet, had specifically stated that since he got extremely high marks in mathematics, they would have no problem in giving him a seat if he had obtained 80 or more marks in science. He further stated that by the time his marks were evaluated, improvement made, admission in the said school was already closed, and therefore he was forced to secure admission in Shercon Higher Secondary School. In his cross-examination, the plaintiff has stated that he had passed his higher secondary secondary exams in the year 2017 from Baptist Higher Secondary School by securing 62% of marks, my lord, in plus 2 from Sercon Higher Secondary School. He got 62% marks, my lord. Whoever is getting more than 60, they have a chance to get admission in medical college, my lord. So in his case, no loss, no damage caused to him. And my lord, here, as I have stated earlier, oral evidence without supporting documents or without having any witness deposition. In his support, there is no evidence at all from any walk of life, my lord. So his own oral evidence only is what he has. However, the learned court below, my lord, stated at the first para at page 99, I believe the version of the plaintiff to be true, as it is seen that every year some students commit suicide due to their examination results, because in today's competitive world, securing good marks in the board examination is the only way to get admission in schools and pursue their dreams. It is well known that in today's world, board examination result is the criteria and yardstick used by educational institutions all over India for admission to a higher class. It is in the evidence that 2015 matriculation examination result was announced on 27/4/2015, and on the day itself, the plaintiff submitted an application for re-evaluation of his mark in science subjects, and the defendants gave their re-evaluation marks on 1/6/2015, which is more than a month. It is my considered opinion that the board has to take an action expeditiously so as to avoid loss of admission for further studies by the student. In this connection, my lord, what I would like to submit to your lordship is he has not lost the chance of getting admission at the right time. Otherwise, he would not have got admission in the Sercon Higher Secondary School at all. So no loss of a year. No precious year is lost. The plaintiff has not lost his chance of getting admission as he got 62% marks in plus 2 exams. So there is no carelessness or nothing of that sort, my lord. And issue number 4, whether the plaintiff is entitled to the relief claim. In the light of the foregoing discussions and findings, the plaintiff has proved his case as regards to the negligence on the part of the defendants and injury suffered by him, my lord. Before coming to that,
So what is the amount?
the amount is,
Is to pay 1 lakh.
although he has claimed 10 lakhs, 70,000, he was given 1 lakh. And the defendants are jointly and severally liable for the same. In order, in view of the discussions and findings in the issues, the suit of the plaintiff is hereby decreed. Accordingly, the defendants are hereby directed to pay an amount of rupees 1 lakh only to the plaintiff within 3 months from this date of order as compensation for the injury caused to the plaintiff due to the Negligence Act. The defendants are further directed to pay rupees 15,000 as pleader's fee and cost of the suit with an interest thereon at the rate of 10% to the plaintiff from this
Okay,
date.
so the amount was 1 lakh. So when you sat in the for mediation, what was the atmosphere? Were you all present?
Mediation.
No.
I
At
was
the
not
time
there,
of
but
mediation.
if I may, my lord, my lord, I'm not sure if it's, but since your lordship had asked, my lord. So in the mediation, our proposal, my lord, was that we will reduce the amount that they will pay us, and then we will be happy. Like if they want to propose any amount, we will be happy. That was our proposal, my lord. They said we are not going to give any money, so that's why it has come
Okay,
back.
okay. Yes.
My lord,
Anyways,
I would like to take your lordship to page 70. That is the deposition, evidence of the plaintiff and his cross-examination, my lord. This deposition of the plaintiff, my lord.
70.
70, yes, my lord. 70. The examination in chief is a repetition of the
Yes.
plaint. So I'm taking to your lordship
the
to
cross-examination.
cross-examination, my lord, at 75. Page 75. Cross-examination is down under by counsel for the defendant. Number one is that of his birth. Number two, it is a fact that I did not annex my progress report of class 1 to 9 because he claimed that he always topped the class in all this 1 to 9. However, no document to prove his case. Number three, it is also a fact that I did not annex any documents which shows that I had always topped in my class. Number four, I have no idea as to whether the instance suit is liable to be dismissed on the ground that I am appearing before the court as a plaintiff, though I have been represented by my father, R. Zombing Moya. In fact, in the plaint, his father to represent him, and the name of his father also reflected therein. However, his father did not give any evidence. His son, the plaintiff himself, appeared and he was cross-examined. Number five, it is a fact that I have a knowledge that there is a provision for filing re-evaluation of marks when I submit the same for myself. At page 976, my lord, para 6. It is a fact that I have no document to show that I have been rejected by St. Paul's Higher Secondary School due to my marks in science subjects. Number 7, I cannot say why St. Paul's Higher Secondary School is not implicated as one of the party in the instance suit. Number 8 is it is a fact that as I was not satisfied with my marks in science, I submitted an application for re-evaluation to the defendants on the day when the result was pronounced. Number 9, it is a fact that I have no document to prove that an application has been submitted through my father to the defendants through RTI in order to inspect my answer papers. Number 10, after revolution of my marks in science, it has been improved from 65 to 82. Number 11, I admit that the defendants had made a bona fide mistake, which shows that my marks have been improved from 65 to 82 marks after re-evaluation was done. Number 12, I also admit that the said mistake was done by the defendants, not because of bad intention for spoiling my future, my lord. Number 13, as per para 8b of my examination in chief, I admit that I am not sure if I have used rupees 30,000 for my traveling expenses. Number 14, it is a fact that I am claiming 5 lakhs as punitive damages, although I admit in my para 11 and 12 that the said mistake was not mala fide. Number 15, it is my presumption that the stature of Sercon Higher Secondary School is not higher than St. Paul's Higher Secondary School. Number 16, I have passed my higher secondary school exams in the year 2017 from Baptist Higher Secondary School by securing 62% of marks. Number 17, it is a fact that I have no idea as to whether I am competent to appear before the court as plaintiff since I have not attained majority. Re-examination was also done by the counsel for the plaintiff. Number 1, what I mean to say in para 6 of the cross-examination is that the reason for not submitting any documents which positively says that I was not admitted by St. Paul's Higher Secondary School because my marks in science was less was because I was positively informed verbally during the interview by the interviewer that had I secured more than the cut-off mark in science, I would have been admitted because I got exceedingly high marks in maths. That was the presumption without having any document to prove the same. Number 2, with respect to what I stated in para 16 of the cross-examination, I would like to add that had I studied in St. Paul's Higher Secondary School, I would have been able to secure more marks than I did now. I know this because I have been informed by my cousin who studied in St. Paul's Higher Secondary School that the manner of teaching there is different and there is more competition, which would surely put me in a better position to secure higher marks. there is also presumption, my lord, hearsay evidence. Cross-examination by the counsel for the defendants, that is, it is not affected. My re-examination number 2 is stated on the basis of my presumption. Those are the cross-examination of the plaintiff as witness, my lord. It is very clear from the cross-examination portion that he has suffered no loss, no precious year is lost, as he got his result, +2 result of 62% marks at the right time without losing any year. And he himself has admitted the fact that there is no mala fide on the part of the defendant in making assessment of his marks. He has made, and he also admitted the fact that he has not used rupees 30 for his traveling expenses. And the way the quantum of compensation granted to the plaintiff is also without any basis whatsoever, my lord. And my lord, I would like to take just 2 documents which is part of the paper book. Page 34. Page 34 is the notification. This was issued, notification was issued on 6th January 2012. As this notification indicates that, I'm not reading a whole thing. Number 1 is a candidate may, within 15 days of declaration of the result, apply for re-evaluation of not more than 2 papers by paying a fee of
Yes, so did he apply within 15 days?
They have applied and they got their result. my lord.
Okay.
Yeah.
Then,
And also, page 36, another notification. This was also exhibited. It is hereby notified for the information of all concerned that in order to ensure transparency and accountability in HSLC examination, Mizoram Board of School Education is introducing the provision for obtaining a photocopy of evaluated answers.
so they could have obtained, yes.
They could have obtained. That was issued in 6th January 2012, my lord. A photocopy of the answer sheet shall be given on request, accompanied by the requisite fee per subject as fixed by the board from time to
Does
time.
it need RTI?
Yes, my lord.
Okay, leave it then.
RTI is not required at all. All the relevant documents required have been enclosed along with the written statement, which are
Okay.
part of the paper book, my lord.
So you have any authorities?
I have some authorities, my lord. Union of India and others versus Usavai Cooperative Housing Society Limited and others, reported in 2014, volume 2, SCC, page 269, para 15 and 19. I'm reading para 15, my lord. It is tried law that in a suit for declaration of title, the burden always lies on the plaintiff to make out and establish a clear case for granting such a declaration, and the weakness, if any, of the case set up by the defendants would not be a ground to grant relief to the plaintiff. Para 19, the legal position therefore is clear that the plaintiff in a suit for declaration of title and possession could succeed only on the strength of its own title, and that could be done only by adducing sufficient evidence to discharge the onus on it, irrespective of the question of whether the defendants have proved their case or not. We are of the view that even if the title set up by the defendants is found against them, in the absence of establishment of the plaintiff's own title, the plaintiff must be non-suited. Here, what I'm trying to emphasize from this ruling is the plaintiff, onus of proof is on the plaintiff. He is essentially required to prove his case. Now, according to his his submission, that he applied for admission in the St. Paul's Higher Secondary School and he was rejected. His application was rejected on the ground that his science marks was lower than expected. So and so
No
on and so
documents.
forth. However, there is no document to show that he has applied for the admission in the St. Paul's Higher Secondary School at all, and no supporting document to that effect, my lord. And the other ruling is, which we have just read out and relied upon by the learned senior civil judge, the President Board of School Education and Orissa. Here I'm not reading again, but what I'm trying to repeating is
2007.
Yes, 2007, Volume 1, SCC 603, Para 6 and 16. Re-evaluation is not permissible under the statute of that state school, my lord. So the similar is not the case. In our case, MBSE has the provision for re-evaluating the answer script. The same can be had through the provision. And if they want, they can also have the Xerox copy of the answer script by paying the requisite fees. And my lord, only two rulings, necessary party, State of Assam and Union of versus Union of India and others, reported in 2010, Volume 10, SCC, page 408. 408, Para 16, my lord. I'm reading. We respectfully agree with the observations made by this court in Udit Narayan case AIR 1963 SC page 786 and adopt the same. We may add that the law is now settled that unnecessary party is one, without whom no order can be made effectively, and a proper party is one, in whose absence an effective order can be made, but whose presence is necessary for a complete and final decision of the question involved in the proceeding. In the present case, St. Paul's Higher Secondary School is unnecessary party, without whose presence it is the said school who can clarify whether the plaintiff respondent has actually applied for admission in their school or not, or the grounds or he was rejected. All these things can be clarified by that school only, without whose presence the present suit cannot be maintained at all, and it should be liable to be dismissed outright, my lord. And the last ruling I would like to place upon is Mumbai International Airport Limited versus Regency Convention Center and Hotels, Private and others, reported in 2010, Volume 7, SCC, page 417, paragraph 15. This also, again, on necessary party. I'm reading with your lordship permission. Paragraph 15, unnecessary party is a person who ought to have been joined as a party, and in whose absence no effective degree could be passed at all by the court. If a necessary party is not impleaded, the suit itself is liable to be dismissed. A proper party is a party who, though not a necessary party, is a person whose presence would enable the court to completely, effectively, and adequately adjudicate upon all matters in dispute in the suit, though he need not be a person in favor of or against whom the degree is to be made. If a person is not found to be a proper or necessary party, the court has no jurisdiction to implead him against the wishes of the plaintiff. The fact that a person is likely to secure a right interest in a suit property after the suit is decided against the plaintiff will not make such person a necessary party or a proper party to the suit for specific performance. So since St. Paul's Higher Secondary School is a necessary party in the present case, without whose presence the suit cannot be adjudicated. And in fact, we have pointed out in our written statement that the St. Paul's Higher Secondary School is a necessary party, without whom the present case is not maintainable. That was reflected in our written statement. However, in spite of that, no appropriate action was taken in time. Now it is too late, and the matter
Yes.
is liable to be dismissed outright, my lord. And with that, I conclude my argument and submissions, my lord, and if need be, I may be permitted to give a reply after hearing the counsel for the respondent.
My lord, regarding the evidence my learned friend had mentioned, it's not only on the basis of the evidence of the plaintiff, my lord, that he was denied admission at St. Paul's, my lord, but also the admissions of the defendants in their evidence, my lord. In this respect, my lord, if your lordship will turn to page number 83, this is one of the defendant witnesses.
83.
83 is the cross-examination of the defendant witness number 1. And there, my lord, if your lordship will see
Defendant witness number?
1, my lord.
Okay. Oh. Yes. 83 cross-examination, huh?
If your lordship will see paragraph number 13. I accept the suggestion. I accept the suggestion that if there is a cutoff mark for admission to a school and a student has not achieved that cutoff mark, the student will not be eligible to get admitted to the said school. 14. I admit that it is in the evidence of the plaintiff. So he admitted, my lord, that the evidence we produced is an evidence that is admissible, that the cutoff mark for science stream in St. Paul's for higher secondary school is 80 marks. It is a fact that if the cutoff marks of St. Paul's School is 80 marks in science stream to higher secondary school, the plaintiff, who was initially given only 65 marks, is not eligible to get admitted in the said school. I admit that we do not deny that the interview for admission to science stream in St. Paul's School is on dated 6/5/2015. It is a fact that after re-evaluation of the answer sheet of the plaintiff in science subject, he was given 82 marks, hence making him eligible to be admitted to science stream in St. Paul's Higher Secondary School if the cutoff mark is 80. I cannot say if the error in marking is a result of wrongful calculation or because we had failed to examine some aspects of the answer sheet. 19. It is a fact that the re-evaluated marks were given only on 1/6/2015 to the plaintiff. So more than 1 month after the interview. And then, my lord, number 20. I do not know if we had taken any steps in helping the plaintiff a secure admission in the schools in Aizawl after the evaluation was done. 21. I cannot say if we had tried to take such steps in order to secure admission of the plaintiff to schools in Aizawl after we received the legal notice. So that is the first cross-examination, that is of the D1, my lord, DW number 1. Now, page number 88, my lord, this is the DW number 2's cross-examination. Page number 21. Now, my lord, our argument is this, my lord. The fact that the answer sheets are in the department, my lord, they have possession over it under section 114 of the Indian Evidence Act. If you have possession over an evidence, and if you do not produce it in court, my lord, the presumption has to be raised against you that that evidence is against you. Section 114 of the Evidence Act, my lord. Now, if your lordship will see page 88, paragraph number 21, my lord. I do not know if the question paper in science in the year 2015 is part of the evidence or not. 22. I do not know if the question paper in science in the year 2015 is kept in the Department of MBSC as a record. However,
but the issue whether he was given less marks and later given high marks.
Correct.
That doesn't really make a difference. That's the fact. 65 he secured, later he secured 82.
Correct.
So answer paper, looking at it now and all, doesn't make much of a
That
difference.
doesn't make much of a difference. In fact, my lord, I'm only pointing this out because the Learned Council, my lord, had mentioned these points. That's the reason why I'm pointing this out, my lord. But the fact remains, my lord, that it's not only on the, and my lord, our evidence, oral evidence, they are not hearsay. Simply because, my lord, I was in the interview. I was there as a first-hand witnesses. I experienced it. And because of that, my lord, my evidence is not hearsay. It is evidence from a first-hand experienced person, my lord. So in that respect, my lord, I want to say that it's not only based on an oral evidence, it's an oral evidence which is not hearsay. And this has been corroborated by the evidence of the DW number 1's admission, my lord. And the fact also remains, my lord, that they had not taken any steps in helping me secure admission in other schools after my marks were re-evaluated. So that is so those are the grounds, my lord. Those are the facts, the undisputed facts. Now, with respect to the first point, my lord, the learned senior had raised regarding the necessary parties. My lord, the learned senior had also pointed out some of the cases which we were going to cite. For instance, my lord, Mumbai International Airport case, my lord, the Supreme Court at paragraph number 15, the learned senior had read out, my lord. Says like this: a necessary party is a person who ought to have been joined as a party and in whose absence no effective decree could be passed at all by the court. My lord, in our case, an effective decree was passed. The decree did not affect St. Paul's Higher Secondary School. It was definitely passed, and it is because that decree was passed that they have come to this court on appeal, my lord. If there was any decree which could, this first point only, my lord, it shows that a decree could be passed. A necessary party is a person who ought to have been joined as a party and in whose absence no effective decree could be passed at all by the court. If a necessary party is not impleaded, the suit itself is liable to be dismissed. A proper party is a party who, though not a necessary party, is a person whose presence would enable the court to completely, effectively, and adequately adjudicate upon all matters in dispute in the suit. At best, my lord, our humble submission is St. Paul's is a proper party. And in fact, they are not even a proper party because the reliefs we claim, my lord, has nothing to do with St. Paul's. Because by the time we got our marks, it was already 1 month after the admissions had been done at St. Paul's Higher Secondary School. So we were only claiming for compensation in our plaint. So there is nothing that St. Paul's Higher Secondary School could do. Anyway, my lord, be that as it may, the St. Paul's at best could be a proper party. If a person is not found to be a proper, and so the court says, if a person is not found to be a proper or necessary party, the court has no jurisdiction to implead him against the wishes of the plaintiff. The fact that a person is likely to secure a right so and so, my lord, that part is not important. And in CPC, my lord, it says like this, CPC Order 1, Rule 10, Order 1, Rule 10. Order 1, Rule 9. Our first submission, my lord, is that we are not a necessary party. At best, we are a proper party. Now, Order 1, Rule 9, it says misjoinder and non-joinder. It says like this: no suit. Order 1, Rule 9. No suit shall be defeated by reason of the misjoinder or non-joinder of parties, and the court may in every suit deal with the matter in controversy so far as regards the rights and interests of the parties actually before it, provided that nothing in this rule shall apply to non-joinder of a necessary party. So the dismissal of a suit would happen only if St. Paul's Higher Secondary School was a necessary party. And my lord, I would also like to stress from the judgment and order itself, if your lordship will turn back to the judgment order at page number 97. Page number 97, issue number 1.
Yes.
Since, it says like this, since the predecessor judge had already maintained the suit after hearing parties on 9/6/2016, further elaboration is not required. My lord, what I'm trying to stress is this, that, my lord, this issue of non-joinder of parties was considered by the court, and it was never challenged at that time, my lord. It was upheld. And my lord, regarding the judgment and order, The President Board of Secondary Education versus D. Subankar, my lord. We have placed it here. I've given a citation, my
What's
lord.
the citation?
My lord, this was reported in 2007, volume 1, page number 603. I have placed the citation here, my lord.
603, huh?
Now, my lord, I'll quickly take your lordship to the facts, which is at page number 605, paragraph number 3. Says like this, my lord. My lord, can I read? Background facts in a nutshell are as follows. Respondent 1 appeared at the high school certificate examination 2004 conducted by the appellant board. Result of the said examination was published on 25/6/2004. Initially, respondent 1 was declared to have passed in the first division, securing 654 marks out of 750 marks. Respondent 1 made a representation pointing out that the marks appeared to have been wrongly mentioned in the mark sheet. Answer script were verified and it was found that the marks awarded in one paper, that is SSH, were wrongly shown as 35, though respondent number 1 had already secured 65 marks. So this case, my lord, even though there was no re-evaluation, my lord, even in this case, there was a correction made.
Same judgment relied on by
Yes,
the-
same judgment we had relied on. The reason it relied on was, my lord, even in this case, improvement was made to the marks. It was pointed out that the mistake occurred due to the wrong entry made in the computer. The error was rectified in the tabulation register and fresh mark sheet was issued on 7/7/2004. Same like us. The revised mark sheet was sent to the zonal officer at Balasore for onward transmission to the headmaster NS Police High School, where the petitioner had prosecuted studies. In September 2004, respondent number 1 filed a writ petition. It is to be noted that the board had constituted a committee pursuant to the direction given in Bismaya Mohanty case. The cutoff mark was fixed at 682. As at that time, respondent numbers 1's mark were taken to be 654, his papers were not examined by the committee. As the candidate had deposited requisite fees for checking of addition of marks, the exercise was undertaken and it was noted that the SSH paper he had secured 71 and not 65, as was posted on the cover page. In other words, the actual marks by the candidate were 690 and not 654 as was originally recorded. The High Court dismissed the writ petition holding that there is no scope for re-evaluation. Now, my lord, this part should not be stressed. The reason I'm saying this is because his mark, even in this case, was improved, my lord, just like us. But directed payment of rupees 20,000 for the negligence of the board. So the court had, the board had made an appeal, my lord. The appeal is at page number paragraph 5. The board is in appeal against the cost imposed. So cost was imposed and the board was in appeal. Now, if your lordship will come to the paragraph number 9. One thing which cannot be lost sight of is the marginal difference of marks which decide the placement of candidates in the merit list. My lord, because of the difference in mark, we also lost our option to go to the school of our choice. The High Court in another case has directed that answer scripts of all the candidates who had secured more than 90% of marks should be rechecked. The said so that part is not important, my lord. I'll not read. My lord, at paragraph number 15. The appellant board is certainly not blemishless. Undisputedly, lesser marks were shown in the mark sheet supplied to the respondent 1. In the first mark sheet, the total marks indicated were 654. Finally, mark sheet was issued showing the aggregate marks to 690. Except putting the blame on the computer firm, the assistant examiner and the scrutinizer, nothing further has been offered by the appellate board as explanation. True, it is the first mistake of the computer firm, but the second correction is clearly on the basis of the paper or for re-addition of marks. It was found that the marks actually secured were 71, while on the cover page of the answer sheet, the marks were noted as 65. For this, the blame has to be fixed on the assistant examiner and the scrutinizer. But that does not provide an escape route to the board. Ultimately, it is the board which has to ensure that the correct mark sheet is issued to the candidates. Since candidates who appear at the high school certificate are of tender age, if by mistake the board indicates to the candidates incorrect marks, it is bound to have adverse effect on the mind of the candidates of tender age. Therefore, it is imperative on the part of the board to ensure that errorless mark sheet is issued to each candidate. The plea of the computer firm that considering the large number of candidates, the mistake is not serious, has no substance. The computer entries are made to ensure accuracy and do away with defects which arise from manual recording of marks. The assistant examiner and the scrutinizer appear to have taken their jobs casually, negligence of the consequences which results from their negligent acts. Therefore, sum of rupees 20,000 has to be paid to the respondent one by the board, out of which it shall recover rupees 50,000 from the computer firm. It appears that the board has taken action against the assistant examiner and the scrutinizer for their negligence. While affirming action taken against them, we express our displeasure for their careless and negligent
Yes,
acts.
so
And-
anyway, any other this thing?
Yes, my lord.
citation?
This was 2017. 2007, my lord.
Oh.
In 2007, they were awarded 20,000 something. Now, my lord, we are in 2000. Case was in 2016. Now, in 2016, there was a very similar case, my lord, but this is of another high court, Madhya Pradesh High Court, my lord. I have provided the citation.
What is the citation?
My lord, this is 2016 SCC online MP 6561. Now, this is the relevant facts are at paragraph 3. I'm sorry, my lord, I gave you a marked one because I had only one copy that time. Paragraph 3, paragraph 4, paragraph 5.
Yes.
And then, my lord, at paragraph 10. And it goes on, finally at paragraph number 11. And then paragraph number 14, my lord, the court gave a compensation of 1 lakh, my lord.
Okay, we'll have a look. Anything else? That's it?
My lord, that's it. But
Oh, okay. Call
Just
the
one,
PSA.
1 second, my lord. The submission made by the learned counsel for the respondent is answered by the ruling I have cited, Union of India and others versus Vasavi Cooperative Housing Society Limited.
and my lord, that
Para
judgment,
15 and 19, my lord.
my lord,
We
that
cannot base upon the evidence of the defendant. The weakness cannot be
Yes, yes,
taken.
no, that I've
My lord.
already mentioned, yes. Heard, where are my PSS? Call them. We don't have to sit at 2.
Yes, my lord. That will be better.
And Koro. Yes. Okay. Besides that, I don't think we have any other hearing matter waiting for today. No.
For today, only this is the fixed item, my lord. My lord, will there be a DB tomorrow? Is there
Yes,
any we
there's going to be DB.
Oh,
I think. Because one matter has been listed for tomorrow, today's DB.
right, ma'am. Can we-
Heard Mr. L.H. Lianshima, Learned Senior Counsel for the appellant, assisted by Ms. Ruth so-and-so.
Ruth, Lal Ruth.
Yes, Learned Counsel. Stuff. Also heard Mr. Victor
Joseph.
Joseph, Learned L. Rente, Learned Counsel for the respondent. Full stop. Hearing concluded. Matter reserved for judgment. Yes.
obliged.